Okay, good morning, good afternoon, and good evening for everybody in all time zones. It's my pleasure and my honor to present now the president of the International Association of Artificial Intelligence and Law, Enrico Francesconi, who is going to give his presidential address today. Enrico Francesconi is research director at the National Research Council of Italy and policy officer at the European Parliament. He's also contract professor of information retrieval and semantic web technologies at the University of Florence. His main research interests include semantic web technologies for the legal domain, legal knowledge representation, AI techniques for legal document classification, and knowledge extraction. Enrico, it's a great pleasure for me to introduce you to the world and also to give the floor now for your presidential address. Please, the stage is yours.
Thank you very much, Giuliano, for the floor. Let me start sharing my screen. I have to go in full screen mode. Okay, I hope that you can see now my screen. Giuliano, can you please confirm?
Yes,
okay.
Yes, perfect.
And can you see the scrolling?
Yes.
Okay. So thank you very much again for your presentation. I'm very glad and honored to give the presidential address at this year edition of ICAIL. First of all, let me say that I'm very pleased to serve as president in this term, to serve the community at this level, and today to give an overview of the long journey of ICAIL conference series from my perspective throughout different seasons of research in AI and law in particular. I'm part of a generation that joined ICAIL in the early 2000s when the pioneers of AI and law have already established the foundation of the discipline. And a new generation of researchers joined ICAIL during a phase of maturity of the so-called web revolution. And in this period, I would like to underline a singularity for the AI and law domain, which is actually the semantic web maturity. There's no doubt, in fact, that keywords like semantic web, smart data, ontologies, linked open data, as well as machine learning and natural language processing are key aspects of the general topic of artificial intelligence and the specific one in artificial intelligence and law. We all know that everything started with the famous article of Lee Levinger of the Minnesota Supreme Court with his article on jury metrics, which underlined a way to approach the law inspired by computational method. But among the pioneers, let me also recall the work done by the National Research Council of Italy in Florence, so the institute where I'm coming from, with a series of international conferences on logica, informatica, and diritto, which were organized throughout the 80s, the first in April 1981, in September 1985, and finally in November 1989. In the same period, the International Association for AI and Law was established to support, develop, and promote the field of AI and law at international level. And here you can see the pictures of all the former presidents of our association. The AI and law pioneers developed their first studies throughout the 80s in the so-called AI winter, which was a period characterized by a substantial disillusion about the expectation of artificial intelligence research and its results. And the main characteristic of the AI, it was a period, let's say, that was characterized by particular characteristics. The fact that in that period we had limited results of a symbolic AI with a toy application, characterized by cost and complexity to represent and keep rules and information, for example, using Prolog. And it was also clear since the beginning that not every type of information is representable in symbolic form. And also the attempt to introduce connectionist models reveal their first limited computational capabilities. For example, related to the perceptron algorithm of the Rosenblatt and the XOR problem identified by Minsky and Popert. And so all these facts determined the so-called AI winter, so the crisis in the AI research. But there's no doubt that currently we are facing a hype for AI technologies with a dramatic growth of interest in the research and of AI, in the applications of the AI, which is usually addressed as the fourth industrial revolution. This is also testified within the AI law domain. We can see here the overall registration trend, which this year reached a relevant number, which testifies the good health of the ICAIL community. And in fact, ICAIL 2021 in Sao Paulo has been a success. It was hard, the decision to go completely online, but the local organizer have taken the risk, refocusing on the opportunities for the online version. And I think that the challenge is one. We had more than 500 participants in the pre-event, around 1,400 registration to the main conference, 89 paper submission, 11 workshops, 1 doctoral consortium, and the new YouTube channel of the association, highly supported by the executive committee for providing new opportunities of dissemination even for the future, not only limited to this very conference. So we are actually at the end of the AI winter, and we can have a look at what happened during these years in the AI law community, and to see what's going on for the current hype. Our first president, Thor McCarthy, since the beginning identified two distinct motivations for this research in AI law: practical and theoretical. The theoretical motivation aims to gain a better understanding of the process of legal reasoning, legal argumentation, and using computational models and techniques. And the practical motivation aims to build intelligent legal information systems supporting legal practitioners and decision makers and citizens. And since the beginning, Thorne underlined some of the key questions in our domain. So how much of legal reasoning can be reduced to reasoning with rules? And how is it possible to reason with cases at all? Or is it possible to develop a computational theory of legal arguments? In order to respond to this question, Thorne identified a possible solution in the need of a deep conceptual model. And he also identified an obstacle in the so-called knowledge representation problem. That's why in ICAIL 1989, he introduced a language for legal discourse. On the other side, Trevor Bench-Capon underlined that intelligent legal information system for most practical application can be built without deep conceptual models. An expert system, as we used to address the system at that time, can be based on formalization of legislation and faithful representation of legal rules. That's why he introduced a key concept, which goes under the keyword isomorphism. And moreover, he try to identify the possibility to learn the rational underlying decisions given only a set of decided cases. And he wrote an interesting paper in ICAIL in 1993 in this respect. Now, they seems to be a different position, but to my mind, they represented complementary position, which aim to address two different and complementary point of view in AI and law research: the top-down approach and the bottom-up approach to AI and law. Which approaches that later on has been developed in terms of rule-based or case-based reasoning, or knowledge system or data systems. But these two approaches since the beginning laid the foundation for going out from the AI winter. And in fact, since that time, lots of research has been developed in several domains, like, for example, subdomains of the AI and law, for example, legal reasoning, in terms of developing profiles for non-monotonic reasoning, for rule-based approaches to the feasible reasoning, models for adversarial legal reasoning, and deontic logic. Similarly, other works address the problem of the general theory of argumentation, the description of dialogues between parties, the analysis of rules and precedents, the problem of persuasion and values in legal arguments, argumentation schemes, and arguments and stories. And more recently, the problem of legal reasoning in conjunction with ethics and explainable AI has been underlined. In the early stage, we had the famous Cato system, which aimed to address the problem of case-based reasoning and factors. And later on, other works are related to deontic logic, responsible AI, and evidential reasoning have been developed. Finally, lots of work have been carried out in data systems to introducing connectionist models applied to the legal domain, to legal information retrieval and discovery, for argument extraction, for legal predictions, legal text summarization, legal network analysis, and quantitative reasoning. One of the first attempt to bridge the gap between case-based and rule-based reasoning was carried out by Kevin Ashley and Wiener Riesland in the IPO system for introducing reasoning with cases and hypotheticals, and in particular in the system Cabaret, including rules and cases to solve case-based reasoning problems. And a similar problem was underlined by Carl Branting, which underlined the need for building explanation from rules and structure cases. In ICAIL 2019, our former president, Bart Verhey, underlined and identified a target in 2025 as the date in which we could bridge the gap between knowledge system and data system in AI. He addressed the problem in terms of AI as law, meaning the process for building hybrid systems connecting knowledge representation and reasoning techniques with machine learning. Now, the lesson learned from the first AI debate is that we have achieved lots of theoretical achievement in terms of both symbolic models and sub-symbolic or connectionist models, but still a limited number of large-scale applications. So we have now, I think, to wonder why this actually happened. From my point of view, this happened for the strict link that there is between we can establish between AI and knowledge, and which is also at the basis of the first period of the AI winter. According to Alan Rich of the University of Texas and Kevin Knight of the University of South California, intelligence requires knowledge. And the AI winter was mainly due to the insufficient amount of knowledge. Now, managing knowledge poses some problems. It is voluminous, it is hard to characterize accurately, it is constantly changing, and it differs from data because it needs a semantic organization. But in the early 90s, AI meets the web, and this changes everything. In fact, this poses actually the ground for going out from the AI winter, because the web can be considered as a source of knowledge for AI, for the availability of a huge quantity of information in digital format for the development of AI systems. And also the web is a stimulus for AI development, because internet and the web in particular need advanced AI applications for managing data. So the evolution of the AI has followed the web, the evolution of the web. We all know that currently we are in the so-called Web 3.0, starting from derived from the Web 1.0, so the static web, the Web 2.0, also known as social web, and finally, currently we are in the maturity phase of the so-called semantic web or web of data, or sometimes also addressed as the Internet of Things. The semantic web has specific objectives, so the technological and semantic interoperability between information systems, so to give the possibility of advanced information services. A great boost to the development of the semantic web in large scale was given by the famous article of Tim Berners-Lee with introducing the famous 5-star rating schemes for linked open data. And from that time, in 2006, we have had a dramatic growth of the linked open data cloud. This is a picture from 2007, from 2008, 9, 10, 2014, and from that time, the phenomenon has exploded. So going back to the Rich and Knight motto, intelligence requires knowledge, we can say that knowledge is nothing but a combination of data and semantics. But knowledge is actually on the web, and in particular, we can say that knowledge is on the semantic web. And knowledge in the semantic web is also important for AI in law, because it provides semantics for a top-down approach to AI in law, in terms of legal knowledge representation, reasoning and argumentation, planning and explainability. And also it provides a large amount of data, or smart data in particular, for bottom-up approach to AI in law, in terms of machine or deep learning and natural language processing for rule-based or case-based systems, argument mining, legal information discovery and retrieval. So we are clearly in the summer of AI and law, as we have seen before, with lots of opportunities for developing interesting and effective systems for of AI for the law domain. And we are, I think, in the summer because actually the semantic web is now mature and it represents the basic infrastructure for AI, because it provides languages for knowledge representation, and it provides also smart data for intelligent systems. Now, from the lesson learned in the AI and law debate, we have seen the need for knowledge models, for languages for knowledge representation, the need for describing rules and having them the possibility to activate such rules, the possibility of developing logic systems and algorithms for legal reasoning, and having the possibility to exploit data and smart data. And this is actually what the semantic web does. So the semantic web is an infrastructure also for AI in law, in the law domain. It provides languages, so standards and languages for legal knowledge representation, and it provides smart data for legal autonomous agents to mimic intelligent behavior. So the role of the semantic web for AI in law is rather clear. It provides standards, it provides and languages, it provides linked open data, so smart data, and it provides a stimulus for developing machine learning and deep learning facilities for transforming the law into code. And having the law as code, we have the possibility to exploit smart data for developing AI and law application in large scale. And the semantic web in the AI law domain has already been developed quite a lot. And we have interesting solutions developed by the University of Bologna, from the University of Amsterdam, and also Kevin Ashley in a specific article identified the importance of ontologies for analogical legal argument. And this is also the scenario of my research, which is actually addressed to the representation of legal rules has described according to two different levels of abstraction in terms of provisions, has a set of signs organizing words and sentences for creating normative statements, and norms for in terms of the meaning or application of such normative statements. So we can say that provisions are textual objects that can be used for applications like information retrieval or legal drafting, and norms are social objects. And so we can use such representations in terms of, let's say, legal compliance or other such kind of applications. So in my research, I developed a model which is called provision model using semantic web standards. And this model has been used for legal drafting activities in terms of model-driven legislative drafting and regulative impact analysis. We have used such model for semantic annotation of provisions by machine learning and natural language processing, so basically for extracting knowledge from legal text, to develop legal information retrieval services, implementing, for example, Opheldian reasoning within a description logic framework. And more recently, the description of norms have been used for legal compliance checking, still in description logic framework, a decidable framework. Now, one of the research questions I think that has to be underlined is to identify sufficient conditions for implementing legal reasoning within the description logic framework. And in particular, for example, using also extension to this, to the classical description logic in terms of DL rules or DL safe rules. We can address several problems within this framework: standard or temporal deontic logic, non-monotonic or diffeasible reasoning, argumentation schemes, and legal reasoning in general. The motivation is that we can use available reasoners within a decidable computational framework. And the key hypothesis in my view is that the key factor is the quality of legal knowledge modeling. And some examples exist in literature, some examples coming from the University of Amsterdam, another interesting work from Guido and Serena about using linked open data for legal compliance. And I also developed my research within this framework, for example, for modeling of Opheldian reasoning within a description logic framework, introducing specific relations in terms of implicit and explicit knowledge, of implicit and explicit provisions. And more recently, I developed a model for legal compliance checking within the description logic scenario. So the regulated scenario can be represented as a domain ontology, and the deontic rules can be expressed as property restrictions. And this model proves the ability to cope with some profiles of norm divisibility. So I think that within this framework, we have several opportunities to develop AI systems in large scale. And in order to develop such system, we have to exploit the dramatic growth of data that will be available from here until 2025. And this is a picture of the data growth prediction. And the opportunities for AI in the legal semantic web or in the legal domain in general is sizing the opportunities of the next data wave, combining top-down and bottom-up approaches, so using semantic web standards and inference tools which are already available for legal reasoning, machine and deep learning for legal knowledge extraction, data for system evaluation compared to existing baseline, and finally, exploiting interoperability between information systems. Also, from the point of view of the political point of view, recently the European Commission published a white paper on artificial intelligence, which aimed to promote the creation of excellence and testing centers that can combine European, national, and private investments. The aim is to promote a new public-private partnership in AI, data, and robotics, and promoting also the adoption of AI by the public sector. And finally, creating an ecosystem of trust, so a regulatory framework for AI. So I would say that the AI research is highly supported by the European institutions. And this is actually what the European Commission is working on. So to create, in particular, the European Union Open Data Cloud centered on EU law. And we can see here the picture of the map, let's say, of the data managed by the seller repository of linked open data managed by the Publications Office of the European Union. And recently, the European Union Open Data Portal has been released. This is the official portal for European data. And by 2021, also the European Parliament will publish the European Parliament Open Data Portal, reachable at this address. And so we can see that there is a great interest in these topics, in particular from the legal tech companies and startups. And you can see here from this picture from the Bill Anderson web page, how rapidly the legal tech is expanding in the legal matters. So we have companies and startups in the topics of smart contracts, e-discovery, security and compliance, transaction management, document analysis, case management, legal research, document automation. And actually, this is what also Richard Susskind told us, has invited speaker at ICAIL 2017. Actually, according to Richard Susskind, we have to catch the momentum, because the legal institutions and lawyers will change more radically in less than 2 decades than they have over the past 2 centuries. And the same concept was expressed by Katie Atkinson in her presidential address of ICAIL 2017. She said that plenty of law firms are interested in hearing about what our research can offer. So now we have seen how many opportunities we have in this domain. And let's take the liberty of dreaming a bit in the summer of AI. So what's going on in the next? I think that the next generation of AI system will be linked to the evolution of the web, and in particular in what in the literature is addressed as Web 4.0, or also called symbiotic web, where humans and machines can interact one to another, and machine will interact as well. So nowadays we have already personal software agents, but in the next future we will have more advanced system for booking flights, for making the best economic investment according to the user financial risk profile. We will have autonomous of self-driving cars and so on. But in particular in the legal domain, as well as in the Web 3.0, we have the law understandable and processable by machines. In the Web 4.0, we can have intelligence agents for legal data mining and e-discovery, and in particular, the creation of a system to act as digital judges with knowledge of personal profiles, specific cases and laws, taking decision on legal dispute. Now the question is, to what extent an algorithm will be able to substitute or support the human legal reasoning. In order to respond to this question, we can make a reference to the so-called paradox of Hans Moravec of the Carnegie Mellon University. He theorized the time of human equivalence. At that time, T0, human intelligence and artificial intelligence will be no more distinguishable. So if it exists at that time, the research in AI will be reduced to an empty set. So will it be the end of AI research? In order to respond to this question, we have to respond to other more specific questions. Does a human judge argue by deductive categories only? Can we say that the roles of emotion, are there any roles in the emotions in taking decisions? Will a judge, a digital judge, emotionally neutral, be fairer than a human judge? And finally, the question of the question, I would say, is the human brain algorithmic? Well, to answer to this question, we can refer to a famous theorem, the Gödel theorem of incompleteness. According to the Gödel theorem, a coherent or non-contradictory system of rules is necessarily incomplete. That is, that there are truths that cannot be proved with the axioms of the system itself. Now, truth that cannot be proved means that they cannot be derived automatically. Now we can say that a computer is a set of circuits that reproduces logical, coherent, and consistent rules of thought. So basically, computer is an incomplete system. But humans seems to act differently. Humans guess as true claims not derived automatically. They guess the axioms. So we can say that human brain seems to reconcile consistency and completeness of a system of rules. So a question is human brain an exception to the Gödel theorem? According to Roger Penrose, this is the case. Human brain is not algorithmic. Roger Penrose is also Nobel Prize this year for physics and from the Oxford University. So this is a famous motto of Roger Penrose: human brain is not algorithmic. We can say that human brain is not a Turing machine. So in order to get closer to human intelligence, will AI have to manage emotions and intuitions? Well, this is actually what Joshua Benjo in ICAIL 2019 told us as invited speaker. He said that lots of knowledge is intuitive. So in order to deal with let's say intuition and emotions, we actually have to deal, according to the literature, to the Web 5.0 or emotional web, where human and machines interaction will comprise emotions. So emotions and intuitions will be processable data. So will it be a matter for quantum computing? Well, we actually don't know yet if this will be the case. But anyway, we can say that at that time in the Web 5.0, where emotions will be processable data, how will you be able to persuade a digital judge? So with this question, I thank you very much for your attention, and I look forward for your questions.
Thank you very much, Enrico, for your very inspiring presentation. I'm checking here whether there are questions from the audience. Okay, there is a question by Floris Bex. Hi, Floris. Do you have an idea on how the European Union wants to cater to both AI innovations and AI regulation, given the draft AI regulations?
The European Commission, as far as I know, especially with the white papers on artificial intelligence, is promoting both of the issues that has been raised. Have been raised. So both the technical aspect and the regulatory aspect. In particular, the role of the institution is to promote the cooperation between private and public initiatives. And I think that especially at the level of a European institution, the keyword AI seems to open many doors, and there is lots of interest in this respect. So I think that it's really time to catch the opportunities from both the technical point of view and the legal framework point of view. And I think that we can obtain, let's say, we can have an audience in this respect.
Okay, we have a question by Trevor now. The availability of so much data is a mixed blessing. We understand that the law, better by the thorough analysis of a few carefully selected and reported significant leading cases, as we did in good old-fashioned AI law, that from a very large number of routine cases where the decisions may not tell us anything and the quality of decisions may be variable, more is not necessarily better. So it's actually a comment, if you would like to comment on.
Yeah, I totally agree with Trevor. That's why I think that the combination of data and semantics is a way to filter at best the relevant cases, for example, that can be prototypical for solving a specific case or to, let's say, describe a specific state of affair. I totally agree that having lots of data is not a solution, but having data allows you to train machines in a better way, to implement tools that can be more selective, and we can introduce, let's say, knowledge in our systems, which is actually seems to be something that is missing, or let's say not is missing, is needed for developing AI systems, and in particular AI and law systems.
There is a question now by Bart Verheij. Thanks for a very interesting talk, he first says. Then the semantic web is especially good at recording and managing the law as it is. What would you say about the dynamical development of law, both in the general rule of law and its application in a concrete case? I would add also the dynamics of legal change and also the interpretation of law, which is based on changing and adaptation of the content of law.
Yeah, I don't know, maybe I'm biased, but I would say that this is actually what you can do with semantic web technologies. For example, the same piece of legislation can be interpreted in different ways by different actors. And you can, let's say, implement a specific ontology that allows you to provide a view on a specific piece of legislation, or to use another view given by another player, which might be more authoritative than the other. Similarly, the dynamic nature of the law can be, it's actually represented using semantic web standards. There are already lots of, let's say, systems that allows you to create, for example, the consolidated version of a piece of legislation, which can change over time. So, as I said, maybe I'm biased because I'm working in this field, but in my view, you have an effective framework. You have, let's say, the language, you have the standards, you have the possibility to create your knowledge models that allows you to provide specific views in terms of interpretation at a specific point in time of the evolution of the law. So this is, I think, this is an important aspect to consider.
Oh, Mikhail Rakshevics is thanking you for this great address, and he's questioning you. He's curious about your opinion concerning automating creative processes, which is essential to the work of lawyers.
Yeah, I don't know, Miha, maybe you mean creation of, for example, automatic document drafting or contract creation and so on, I think. Well, as I said, you have to consider all this system as a support for the work of the lawyers, but they can streamline a bit, very much their work, especially obviously in repetitive tasks. For example, at the beginning of my career, I worked in the field of legal drafting, legal document legal drafting. Yes. And we provided some tools for the creation of a model-driven legislative drafting. So having, let's say, a support for the automatic creation of documents using a specific semantic model. This can be beneficial for the clarity of the law, for let's say improving the accessibility of the law, and for let's say making a so-called better legislation, which is, by the way, one of the main let's say action of the European Commission that they are promoting. They have been promoting for quite a long time.
Thank you. Jaromir Zavelka is following Trevor's question, and he comments that he remembers that at ICAIL 2013 in Rome, the lack of AI and law datasets was identified as one of the biggest issues for our community. How do you think this has changed? Is it still a priority?
I think it's a priority, absolutely, because it allows you to, for example, to train, let's say, connectionist models in an effective way. Let's say the movement that can overcome this problem is given by actually what we have called, or we have addressed in the presentation, as the linked open data approach, because you don't need to have a specific repository of this content, but this content is distributed over the web according to specific standards and specific APIs, so application program interface. This allows you to have a more flexible and let's say scalable solution for let's say filling the gap between knowledge systems and data systems, as my friend Bart used to call the problem.
Enrico, I also have a question. As you have addressed, this is the key aspect of our summer, as you have mentioned. The key aspect is the combination of knowledge systems with data systems. And you mentioned that we are in the first steps in this direction. When do you believe, what's your guess for the time that we are going to reach maturity in this research challenge, considering that you are considering also your dreams today? So what are your dreams regarding this particular desideratum for the research on AI and law?
Yeah, for me, as much as we follow the combination of a top-down and bottom-up approach, the more we address this combined approach, the better will be to reach this coordination between knowledge system and data system in an effective way. So I think that this is actually two different perspectives or two different sides of the same medal, the same coin. At the end, you will reach the same point of contact from top or from the bottom. You need knowledge models for reasoning, and you need data for implementing systems. So at the end, these are the two combined approach that, let's say, will be beneficial for creating systems and in particular AI and law systems, which is effective for large scale applications.
Jack Conrad is thanking you for your talk, and he mentions that you ended your talk with a look to the future and properties of Web 5.0 that this web might embrace, including a point where machines and as well as humans processes emotions. How essential do you think such a property is for AI systems in order to achieve further progress, that they possess such human-like characteristics to be effective? So how essential it would be?
I don't know. I can say that if you go in a trial, I don't think that you can consider that the decision of the judge is completely, let's say, deterministic or follow, let's say, deductive path. So sometimes actually emotions, or let's say more, let's say more fine-grained elements affect the decision of a judge. So if you want to mimic at the end completely this attitude, you have to consider also this this aspect. I know that now it seems like a dream, as I said before. It's more a matter of science fiction rather than research. But actually, already there are services on the web that works according to preferences of the users. They want to let's say exploit their sentiments, the famous sentiment analysis, and it's not completely out of the research framework to think about this aspect, because if you are able to let's say govern this phenomenon, you will be able to create really systems that mimic the human brain. But as I said in my presentation, probably there is a structural limit, or probably definitely there is the structural limit given by the Gödel theorem, which says something very plain and I would say trivial, but very simple, that the fact that humans have let's say aspects that are hardly modeled by machines, which is subject to the Gödel theorem, while humans seems not. So this is also, I would say, a sort of philosophical aspect to consider. But this doesn't prevent us to follow this dream and to go through this kind of research, because it might open unexpected doors.
Great. Vern Walker is congratulating you for your excellent presentation. And he says that he would appreciate your thoughts on whether practical applied theories of legal reasoning are falling behind the availability of technical tools.
Sorry, Giuliano, could you repeat that?
Yes, he's asking whether, for your thoughts on whether practical applied theories of legal reasoning are falling behind on the availability of technical tools. So if there are no enough technical tools for applied theories of legal reasoning.
No, I would say that this is not probably essential, because you can follow this line of research even from a pure theoretical point of view. It is also true that at some point, if you are a researcher in AI, you want to have to see something applied, I think. It's important, from my point of view, to identify, as I said in my presentation, the framework. Let's say the limit of specific profiles of legal reasoning that can be implemented of using existing reasoners, which are, for example, available for description logic or for other profiles of logic. But I don't think that the lack of tools prevent us to go through this line of research.
Trevor is now with another comment. He's saying we need analyzed data, example, the ascription of factor to cases as in Cato, rather than raw data. We also need benchmark data sets to allow comparisons.
Absolutely. I totally agree with Trevor. We don't need raw data, we need smart data. It's exactly the point of my presentation. You need to extract knowledge from raw data. You need to have data that are semantically described so that, let's say, intelligent systems can process those data and, let's say, implementing profiles of rigor reasoning or, let's say, deductions that you can obtain if you have this kind of data semantically qualified. And this is also a contribution to the explainability of AI. Which is sometimes not true using raw data or pure subsymbolic systems. So I agree on what Trevor said.
And Enrico, being carried on by your dream on an emotional web, and we know that our works on AI and law and the models of legal reasoning that are discussed and explored are mostly based on legal theories whose tradition is analytic in its essentially. And now that you want to open room for discussions on emotion, do you think that we should be open and to visit again within the community discussions on legal theories that oppose the analytical trend with virtual theories, for instance, that open room from emotions in the legal analysis of particular judgments?
Yeah, for me, this can be the case. Obviously, it's for now. I think that we know our limits, but nothing prevents us to think different, as someone else has said, and maybe to go in a direction that seems to be full for someone, but at the end, it's a way to try to approach the reality and to reproduce the reality in a proper and effective way. So I agree. I agree on that. I agree on what has been said.
Okay, Enrico, we have run out of time now. It was really a great presentation and very interesting discussion. Thank you very much for the insights and for the inspiration to the community with your dreams. Thank you very much, Enrico.
Thank you very much, Juliano. Thanks to all of you for your attention.
Okay, thank you.
Thanks.